मतलब item number 12 of today's list, with the consent of my other side, let this matter be taken up after the puja vacation.
I have no. Lordship, can I perhaps fix a date subject to Lordship's convenience?
9th of
Make a
November.
mention immediately after puja vacation. That will be great.
Please, Your Lordship. Lordship, with the consent of the other side, I'd like to mention item number 4, Your Lordship. Lordship, in this matter, Your Lordship, we need to file a rejoinder, Your Lordship, affidavit in opposition to the interlocutory application filed by the respondent. Your Lordship, I pray that the matter may be listed in the next week, Your Lordship.
After puja vacation. After puja vacation. Yes, next.
Deeply.
Yeah, please, yes, Your Lordship. Lordship, I would like to mention item 2 of daily list, Your Lordship.
Item
2, Your Lordship. Here we have taken consent from the other side also and circulated the adjournment petition. Your Lordship. Matter may be taken up after vacation, Your Lordship.
Okay.
Deeply obliged.
Please, Your Lordship. This matter relates to the declaration of the petitioner foreigner of post 71. Whatever he has filed everything, my lord, but he has not appeared to examine himself or to adduce evidence or to prove the document, though he has filed. That's why the court was under tribunal was under compulsion to proceed and pass the order. Opportunity was given, but the problem is that I have mentioned on last occasion also brought to your lordship notice. The lawyer who was engaged, my lord, he did not inform him to come and to adduce evidence. I don't blame the lawyer, but at the same time, I think it is the duty of my learned friend advocate to communicate and to come with evidence. He has also not taken any steps also. As a result, so tribunal was under compulsion to proceed with the order. So my prayer is that if your lordship be kind enough to remand the matter, even if require with cost, madam, I am ready to face it.
Mr. Payeng. You have heard Mr. Bitross that he in remand of the but it appears from the opinion please come to page number 40, Mr. Payeng.
40 man.
Read the para 2.
It appears from the record that initially notice was issued in the name of Johorul Sheikh to show cause as to why he is not to be declared as foreigner under Foreigners Act 1956. On receipt of the notice dated 29/8/2015, OP Prosody appeared along with his engaged advocate and filed his written statement 11/12/2015 and evidence in CFON 2/6/2016, along with few documents in photocopy only, and since 9/5/2016, This case was fixed for cross-examination and hearing. OP Prosody has given sufficient opportunity, but he taking this and the plea only to dragging her case. Hence, the opinion final order is passed.
Now please come to page 41,
First parameter,
41, third and fourth.
third and fourth. I consider it relevant for third parameter. I consider it relevant for mentioning here that section 3(8) of the Foreigner Tribunals Order 1964. It provides that Foreigner Tribunals give the OP 10 days time to give reply to the show cause and for the 10 days time to produce documents in support of his case. Apparently, in the case at hand, since the date of his appearance with the documents and arguments, till the last date in the case, OP Prosody has been granted more than 60 days time for filing and submission of documents and arguments, instead of 10 days time as prescribed by the aforesaid Foreigners Order 1964 up to date.
Next para.
In view of the objection of the objection of the institute as aforesaid, and also pursuant to the direction of the Honorable Guwahati High Court, reported on so and so 2003 1 GLT 809. It is thus appears to me that despite having reasonable opportunities, the OP procedures failed to present a submission of documents and arguments within time as prescribed to him. So far, do. As even that found absent. As such, having no alternative, I am therefore constrained to take up the case for passing the final order. Accordingly, the instant case is declared on contest against OP proceeding.
So matter was pending for cross objection and hearing.
Yes, ma'am.
Now, if you read page 41, first para,
Yes, ma'am. I have minutely perused the records and the materials available there. I have perused and scrutinized the documents. Exhibit A is a photocopy of 1966 voter list in the name of Batullah Mandal. Exhibit B and Exhibit C are the photocopy of the voter list in the year 1994 and 1997 in the name of Montaz Ali, Jorura Khatun, and Jaharul Haq. Exhibit D is a photocopy of the voter list of 2014 in the name of Jaharul Haq and some others. Exhibit D is a photocopy of affidavit in the name of Jaharul Haq alias Jaharul Sheikh. Exhibit E is the photocopy of the electoral photo identity card in the name of Banis Uddin. But he failed to produce the original or certified document in support of his claim of the nationality of citizenship of India. Mere filing of documents or marking of documents as exhibit by the OP proceeding is not enough. Not only the documents, but also the contents thereof would have to be proved and relevancy established as per mandate of the Section 9 of the Foreigners Act 1946 as explained by the Honorable Supreme Court in Sarbananda Sonowal versus Union of India. So it therefore reveals from the case record that OP proceeding he has absolutely failed to discharge his mandatory burden to prove and establish that he is not a foreigner as enlisted under Section 9 of the Foreigners Act 1946. The reference thus stands unassailed and unrebutted, and accordingly it's allowed.
tell us, is there any requirement of demanding the back matter to the tribe?
My lord, here in this case, my lord, it's not that he was not know, he didn't know. He right here. He is known. He is not, my lord, known about the proceeding. Had it been a case of, my lord, non-servicing of notice, that's a different case. Here in the case, he deliberately, my lord, kept himself absent from the proceeding. Your lordship may kindly see, he has submitted these documents, Xerox copy of these documents, file is his WS and written, my lord, as well as evidence. Thereafter, it was his duty to prove by appearing and, my lord, producing the original of the oldest document. So it cannot be said, in fact, it cannot be said an expertise, my lord. It is, my lord, it is a case where he contested but failed to my lord, bring the evidence to prove his case. So in that aspect, my lord, one thing, we have numbers of judgment of this honorable court. First of all, my lord, with regard to this remanded, whether it can be remanded.
Please come forward.
Yes, my lord.
That bench, in fact, Madam will not be available from 16th.
Yes, my lord. She will be in Itanakar.
So
Yes.
this is happening. We have only from 9 to 13th.
9 to 30, my lord.
So we do not know on which date that bench will be constituted, but it will be constituted on a particular date.
My
So we
lord.
cannot consider, we cannot give that particular date, whether it be on 9th or 10th or 11th or 12th,
All right, my
but
lord.
it will be constituted
My lord.
on a particular date prior to the vacation, prior to.
My lord, our difficulty is the senior counsel also has to travel from Delhi and
True, true.
it coincides with part
So what is happening in that case? Let the bench be constituted first.
Yes, my lord.
Let's see on that day whether it is possible or not for you.
On the 9th, no, my lord.
We do not know whether it will
Okay,
be on
okay.
9th or on some other day.
All right, my lord.
Okay.
In fact, I got stuck in traffic. I started from home at 9. But,
Doesn't matter.
because of that,
You have made a mention, we have discussed the issue,
my
but
lord.
it may not be on 9th.
My
9th is a motion day, as you know.
My lord.
So basically, what will be the bans on 9th and thereafter?
Yes, my
But it will be constituted on that day because we have a only from between 9 to 13.
Yes, my lord.
We cannot give you the date as on today.
Yes, my
Right.
lord. My
On that, let the bans first be constituted and we will see whatever.
my lord. The difficulty is with the senior counsel that has to travel from Delhi. That's why, like,
If your senior counsel is available on that day, well and good.
yeah.
If he is not available, then we will do something. We'll arrange it.
Otherwise, yes. On 10th also we have a review matter here,
That
but
you
it
have
is
told
pending
us.
before court number 5.
It may not be possible on 9, 10. Hereafter,
All
maybe
right,
on
sir.
12 or maybe on 11.
My lord, should I keep in touch with the registry so that it can be coordinated with your court properly, my lord?
No, after you made a mention yesterday, we have discussed the issue.
Yes, my lord.
So on which date it will be constituted, we cannot assure it.
All right, my lord.
They
Obliged,
are aware of the
much,
fact.
much obliged,
You be in touch with the registry. Let's see.
my lord.
First of all, my lord, with regard to because this is an admitted position, he appeared, submitted
From
WS.
2016 January,
Yes, ma'am.
the proceeding did not appear before the tribunal.
Yes.
And
Since
the opinion was issued only in 2018.
2018. So it's not a one-day case, my lord.
2019
And,
merit.
1990. So one thing I like to draw your lordship. This is admitted position that he have filed WS as well as evidence, but he didn't come for my lord proving of all his case. So the tribunal has to pass that order. Now, can it be, my lord, remanded only on the basis of, because he has no other ground, on the principle of natural justice? That is it on the ground of principle of natural justice, he is to be remanded. That is his only plea. Otherwise, there is no case. So it's an admitted position. He didn't prove that case. To that effect, my lord, we have a judgment of this honorable court. In the same line, my lord, your lordship will find that is 2016 1 GLT 273. 2016 1 GLT 273. That is read appeal number, my lord, 186 of 2015, your lord. Ayub Ali and others. Here also, my lord, in this case, the proceeding fails to produce adduce evidence and bring evidences, witnesses by bringing witnesses. Para 15 and 16, my lord. 16 is the para 1/6, my lord. That is the law ratio, my lord.
Para
Para 16, 15 and 16 may be same, my lord.
15 and 16 is in the sub-para, I think so, in para 14.
Yes, my lord.
It is
Is
in
it,
para
my lord?
14.
Maybe, my lord. But yes, yes. Para 13, my lord. Para 13. Para 13, sub-para 15 and 16. My lord.
Candidate,
My lord, para 15. The petitioner did not adduce any evidence is not a dispute. The thrust of the argument of the learned counsel for the petitioner is that the petitioner have been denied reasonable opportunity to enable them to discharge the burden cast upon Section 9 of the 1946, and one more opportunity should be granted to them. 16, my lord. Principle of natural justice cannot be put into a straitjacket formula. It is more than 3 decades that the issue of influx of foreign nations has been in public domain in the state of Assam. Process of determination of question of citizenship cannot be a one-way traffic, leaning only in favor of the person whose citizenship is doubted. Interest of the state is also of paramount importance in the unabated influx, has the potential to affect the integrity and the sovereignty of the country. Citizenship of a person, no doubt, is a very valuable right and should be zealously guarded. However, if a person does not take steps for safeguarding his interest, he does so at his own peril. Right to a fair hearing of principle of natural justice cannot be permitted to lead to a partial situation and to be an engine for defeating the very object of the identification of deportation of foreigners. The petitioners had known about the allegation against them that they are foreigners entering into India without valid documents, at least from 2007, even ignoring that earlier part under IMDT Act from 1997. The petitioner all these years apparently did not take any steps to defend their rights in the court proceeding. In the circumstance, I am not inclined to grant any further opportunity in the petitioner, as such course of action according to the perception of the court would be self-defeating. But the Honorable Court, my lord, this is quotation. On considering the matter in the entirety, we have found no infirmity in that judgment under the silence, since it was found to be well evident that appellants had not granted sufficient opportunity to show that they were citizens of India, but they failed to utilize all this opportunity. So, my lord, here also in this case, my lord, he was given enough opportunity to establish his case, but he failed to adduce evidence and fails to prove his documents, whatever he submitted. And what, my lord, regarding, if your lordship, I may submit one more thing, my lord. Mere production of document is not enough in this case, because he has produced some documents. That has to be proved by bringing, my lord, the author of or the person concerned. This is, my lord, to that effect, my lord, your lordship will find this is 2010 4 SCC 491. This is in a Life Insurance Corporation of India versus Rampal Singh Bijpan.
Mr. Biswas, take it. 2010 4 SCC, right?
Yes, my lord. 4 SCC 491, my lord.
Yes, which para you want?
Para 25, my lord. Para 25, my lord. 25 and 26.
Yes.
We are of the firm opinion that mere admission of a document in the evidence does not amount to its proof. In other words, mere marking of exhibit on a document does not dispense with its proof, which is required to be done in accordance with law. As has been mentioned here in above, despite perusal of the record, we have not been able to come to know. Para 25 is clear, matter. That is enough. Then, my lord, same line, another judgment is there. That is, my lord, 2000. 2008, 2008, 8 SCC. 2003, 8 SCC. 2003, 8 SCC is 7 4.
7.
Yes, then 2003, 8 SCC is 746.
2003 8 SCC.
Yes, my lord.
746.
7 is probably 752 much. No, 742 much. 746.
Don't think so.
745 may be similar. 745 probably 745. 745. Narabodha Devi Gupta. Narabodha Devi Gupta. 745. That here your lordship will find para 16 mile. This is again relied on Ranji Dayawala. Para 16 it is said, my lord. Reliance is heavily placed on behalf of the appellant in the case of the stranger. The legal position is not in dispute that mere production and marking of document as exhibit by the court cannot be had to be due proof of contents. Its execution has to be proved by admissible evidence, that is by evidence of those persons who can vouch safe for the truth of the facts in issue. That was, my lord, quotation of Ranjit Dayawala versus and Sons, my lord. So these principles were adopted by this honorable court in, my lord, numbers of occasions in different cases, my lord, in foreigners issues also.
So, yes, Mr. Biswas.
Yes, madam. It is apparently fact what my learned friend has submitted before your lordship that it is I failed to appear and to adduce the evidence and to prove the document. Regarding voter list, Mamata Bhomik was the State of Union of India that has been held by our own High Court that electoral documents are need not to be proved. And regarding other, I have filed my chief in chief, but I have not appeared for cross-examination. There is a fault on my part. But I have also mentioned that it was my learned advocate where there was a gap of communication. He never informed me to come. Otherwise, when I have submitted everything in time, why I should be remain away? That that's why at the very outset submit that I will be given an opportunity to prove my documents, my lord, and to adduce any other evidence.
That part we cannot allow. From the stage, it will be only for your cross-examination and hearing, not beyond that.
Yes, your lordship might do it.
Mr. Payang,
My lord.
only from the stage of cross-objection and hearing.
As your lordship, my lord, he has filed evidence. If your lordship allow him to go back, then only from the date of point of cross-examination.
Cross-examination, hearing,
Yes. No more evidence.
nothing.
And it is only for the interest of justice, my lord, for the principle of natural justice.
Third, Mr. S. Business Planet Council is hearing for the petitioner. And I'm at Saldivi, learned PGC. Standing council. Please take your seat. State coordinator NRC. Also heard Mr. Payang, State Council, Home Department, paragraph number 2. 6. AI Ali, Standing Council, ACI. You are there, no? I don't know. P. Pegu. P. Pegu on behalf of and Mr. P. Sharma. For your response. On a reference being made by the Superintendent of Police order Bongaigaon, under IM here during its course. Regarding the necessity of the petitioner, namely Johorul, Johurul, son of late Montaj alias of village Deotari 2 under Manipur Police Station of District Bongaigaon. IMDT case number 366 was initiated against it. After the decision of the case Sarvananda Sonwal versus Illinois PTA reported in 2005, the declaration of the IMDT the issue regarding citizenship of the petitioner was converted to a proceeding under the Foreigners Act 1940. The matter was placed before accordingly, the matter was placed before the Foreigners Tribe number 1, Bongai. Very state IMDT case or registered as a case number PNGN of the FP of the 2040 to 204 of the 08 and one 167 oblique 07. In the said application, the notice was issued to the petitioner to show cause as to why he shall not be declared as a foreigner under the Foreigners Act. Pursuant to the receipt of the notice, the petitioner along with his advocate appeared in the matter before the tribunal and filed his written statement on 11/12/2015 and affidavit in evidence on 02/06/2016 along with certain documents along with certain xerox of the posted copy of the since 05/08/2016 the said matter against the petitioner was pending before the Foreigners Tribunal number 1 Bongaigaon for cross-examination and hearing. but the petitioner did not appear before the trial. In spite of granting numbers of chances to the petitioner to answer a number of chances to him, as the petitioner did not appear before the tribunal, did not appear in the tribunal. After considering the matter, on 04/01/2019, perusal of the written statement as well as the affidavit documents furnished, the tribunal opined the petitioner to be a foreigner but illegally entered into the territory of India or India Assam on or after 25 July. Being agreed with the same, the petitioner on 27/01/2020 filed this writ petition challenging the said impugned opinion dated whereby he has declared post 2050 honorable. It is an admitted position that the petitioner proceeding after filing his written statement and affidavit in evidence before the Foreigners Tribunal number 1, Bongaigaon, on 11/12/2015 and 02/06 respectively, did not appear before the said tribunal. And only after the opinion went against him, terms of the opinion dated 04/01/2019 passed by the Foreigners Tribunal. The petitioner obtained the certified copy of the said impugned opinion on 14/06/2019 thereafter by the challenge. We are aware of the fact that citizenship right is a valuable right of a person. But at the same time, we have also seen that the petitioner intentionally did not appear before the Foreigners Tribunal number 1 Bongaigaon in said after filing his written statement and affidavit. Till the final update. as per the provisions of the Foreigners Act 1946. The onus of proving citizenship, onus of proving the citizenship as an Indian, not foreigner, lies upon the suspect. But in the case in hand, the petitioner failed to prove the relevant documents that he has attached in his written statement affidavit. Preferring to remain absent before the trial for cross-examination. After hearing the Mr. Biswas, learned counsel appearing for the petitioner submitted that the concerned engaged counsel did not explain to the petitioner regarding his requirement to prove his requirement for cross-examination to remain present before the tribunal for his cross-examination. And in that process, inadvertently, the proceeding failed to appear before the tribunal. However, at the same time, Mr. Biswas admitted the wrong on the part of the proceeding to remain absent before the tribunal for his cross-examination. Mr. Payne, learned standing counsel, appearing for the respondent. Taking reliance, the cases of Narboda Devi, NARK, Devi Gupta versus Virendra Kumar Jaiswal, reported in 2003, AS 745. Life Insurance Corporation of India and another person, Ram Pal PL Singh, Vincent PISA, reported in 2010 for SSC 491. Decisions of the Honorable Appellate, as well as the case of Ayub Ali in bracket MD and others versus Unividia and others, decided by a coordinate bench score reported in 2016 1 year 2015. Submitted that as per the provision of the foreigners of Delhi, foreigners within bracket 500 bracket or 94 from under the Foreigners Act and having statutory force is required to dispose of within a period of 60 days by the tribunal after receipt of the reference and that the principle of natural justice cannot be put into straitjacket formula. And that process of determination of question of citizenship cannot be a one-way traffic leaning only in favor of a person whose citizenship is doubted. But at the same time, the interest of the state is also of paramount importance. In that unabated influx has the potential to affect the integrity of Mr. Pang also submitted that the it is the duty of the proceeding to prove the document, and if it fails, prove the same. The tribunal not After hearing the counsel for the parties and considering entire matter, the court in spite of finding taken on the part of the petitioner, decided to give an opportunity to the proceeding concerned, considering if a chance, give one opportunity. Considering that citizenship of a person is a very valuable right. Considering the petitioner is directed to deposit an amount of rupees 7,500 as a cost to the State Legal Services Authority, Assam. Obtaining necessary profit. Thereafter, with the receipt of the positive, the cost is correct. The petitioner shall appear before the Foreigners Tribunal,
Bongaigaon
number 1, in FT case number PNGN of FT of 204/08 and 1167 of 7. On or before 18th of October.
18. May I pray for a little more time?
Give
I
us
have
the
to arrange the amount also, my lord.
on or before 3rd of November. Hereafter, the process of the proceeding of the shall start from the stage of cross-examination. The order include opinion. Consequently,
No problem.
yes, Mr. Das, what is the matter?
My lord, your lordship will tell us the impugned judgment, that is at page 44. I was thinking, my lord, some help will come from the National Medical Commission, my lord. It seems, my lord, that That is not there. Okay. Page 52, ma'am. Sorry, ma'am. Page 52. That is the case, my lord. He is a student. He was a student 2009. He took admission in the MBBS course. He attended his classes for some time. Then thereafter, my lord, he could not continue continue his classes due to various reasons, ailments and all. And this is narrated in page 54. May I read page 54?
Just a minute, Mr.
Well,
Just bear with. Mr. Gogoi, admission in medical colleges is over by 30th September. Admission in medical colleges is over by 30th September.
Otherwise, also, whether from 2009 years left the study medical course. Now, after 14 years, you know, holding linear mallet particular seat when you feels like even whatever be the reason. And mallet there, whatever admissions are given now, after mallet qualifying the need exam. For last 14 years,
You're not on that. Petitioner took admission MBBS after being selected, not to any other.
you can then
Now,
this
because of an accident, could not complete. He later resigned, was allowed to resign. After
then also
then he suffered other medical. And after certain period of time, he was physically. Then he again approached. This time he was rejected. That led to the petition. The reason of rejection was if the petitioner is allowed to admit first year course, then it will block seat of some selected candidates. That's how.
that was my committee.
And accordingly, it is. Now, after 30th of September 2023, is there any vacancy?
Will not be possible after 30th of
No, after 30th of September, no admission can be. Kindly tell us the maybe 5th of October. Any seat in lying vacant in this course?
one.
Now,
11 hours.
that way, that seat cannot be filled up. Now it cannot. Now, whether the petitioner can. Basically,
On merit,
just a minute.
For last 14 years, he is out of it academic. That is his connection because you are under treatment. Now, whether it's fit for otherwise or fit for a medical course, it's not a matter general like matter.
That's what you this team of doctors of Bharati Medical medically examine you, and if you see that he is fit to resume the course, since one particular post, not post, that seat is lying back.
So, that we, after 30 September, by any means,
We are not considering admission, considering his pass.
pass admission matter, just it has gone matter, not lying as on dead matter. That's why I have said matter, he cannot keep on laying a particular seat, which was allotted to him in 2009. Where is that seat matter? The Lordship knows whether student teacher ratio is there. Particular seats have been now been granted by the National Medical Commission. They have given permission to us. We have to fill up those posts and we have filled it up.
Who is appearing for medical council? Mr. Angsuman Bora. Mr. What, Mr. Das, what is the stand of the medical council?
Medical Council of India, in many words, they say that it is not possible because not possible. That is what he says. But your lordship will kindly say one factor, my lord. Page 56. No, sorry, 54. Para 5. Page 55. Impugned judgment, para 5. To a pointed query made by this court, Mr. Bora, learned senior counsel for the commission as to whether there is any bar in respect of the petitioner to complete his MBBS course. Mr. Bora submits that under the Graduate Medical Education Rules 1997, a learner who has joined MBBS course prior to 19 academic session, there is no bar in completing the MBBS course. This is very important. However, for a student who had enrolled after 2019-20 academic session, there is a cap for 10 years for completing the MBBS course. He therefore submits that in respect of the petitioner, there is no outer limit for the petitioner to complete his MBBS course, provided that he has enrolled and started pursuing his studies prior to 2019. So this was the position. My lord, only one aspect of the matter your lordship will only say. Person pursuing MBBS course, first time, supposing two students fails in first year, he is allowed to continue in the first year. Supposing he fails in 3 years, 3 times, he is allowed to continue. He doesn't eat into new seat, my lord. Here, my lord, I have annexed one copy, page 45, your lordship can only see. He was in jail for about 20 years.
That we know.
Then also I have annexed, my lord, page 47, results each of 1915 batch students, where students have failed. Then thereafter he is allowed to continue. So he doesn't eat into, my lord, anybody's, my lord, seat. So what is, my lord, what I disagree in the impugned judgment is the last sentence. That page 56, it says, my lord, permitting petitioner to be admitted in the next semester for the session 2023-24 would amount to depriving the candidates who have already been selected for the. This is not correct according to me, because, my lord, he was allowed to continue in the year 2012, but he could not continue because of other ailments. Then how he was allowed to continue in 2012? It doesn't affect anybody's seat. If there is, my lord, in the before the division bench, court wanted to know whether did he really take admission, did he really my lord, attended classes, did he really? Then we have filed an additional affidavit. We have shown all the practical classes. He has attended, my lord, one semester, one internal, my lord, examination. We have filed in the additional affidavit, and we have also annexed the MRI documents and all those my lord, medical documents in the additional, showing that due to his ailment, my lord, he could not continue his class. And the last sentence which has been submitted by my learned friend, my lord, that it will eat into one seat, my lord, that is not correct. It cannot be correct because MBBS course, a person, my lord, all person doesn't pass. The 2-3% they always fail, but they are allowed to continue. There is system involved inbuilt, my lord. Even in second year, one fails, he is allowed to continue. This is very normal practice. So for this kind of person, there is a, because he has already taken
Mr.
admission, he is
Gogoi,
required to.
That
Well, that,
paragraph
so
5.
far as the submission made by the other side, just now, regarding that, that will be applicable to a candidate who is pursuing the course. He may fail, but he is still pursuing the course. There is a case where he has left the studies in the middle. Whatever be the reason. Now, after 14 years, how can he say that now I want to join? Well, that batch has already passed. It is a 5.5 years course. 2009 to 2014, they have passed out.
No. What
Now, in
Mr.
order to accommodate the
What Mr. Das is pointing at, if a person who is in jail custody for a long period, if he is allowed to complete his
not a
MBBS.
precedent for us.
Secondly, now if let us assume that the petitioner has been considered and allowed to participate, will he take away a seat?
Yes, sir. When will you get admission? It's not that that admission of 2009 still continues. It's like he has forgone, he will have to be admitted afresh. He will have to give the admission fees, This is not for our fault that he has been deprived,
2012, he was allowed to continue, my lord.
Not allowed. There is a statement made by the petitioner in the writ petition. Only a statement. Who was at that point of time, whatever be the reason, by that time, that patch was still there, But now, after 14 years, is it possible, Let him appear in the NEET exam, If he is qualified, he will get a seat. Now, a doctor, specialized doctor, he cannot examine whether he is fit for, health, they can check up. But what about his studies, Whether he is still fit to, pursue the medical course now. It's not a general course, or say, simple, having a bachelor degree or degree.
Let the team, my lord, to do it, my lord.
Cannot, it will have to be by the NEET, We are not the authority to keep, take class examination, give admission to a particular candidate. You will have to appear in NEET. That we have stated in an affidavit, pursuant to the order of this honorable court, division bench order, we have filed an affidavit. We have stated we cannot. That affidavit is there,
No. What do you have to say about paragraph 5 of the impugned?
Yes, regarding that, I can, That's why I said, supposingly he was continuing, he has failed in first year. Within 2 months or 1 month, there is a special exam held for those, who could not qualify, pass out in the first semester. And if they, pass out, then they can, and they are allowed to continue in second semester too. They will pursue, the second semester, but they will have to appear in the first year examination again. It is held within a period of, say, 1 month or 2, to my information, that they have explained. Supposing there is a change of syllabus. Take a situation, that there is a change of syllabus. Then that particular batch, if say he is failed in first semester, then in the earlier old syllabus, the the question papers will be set for that particular condition. And within one month or 2 months, he will have to appear in that exam, and will have to pass out from the first semester. And at the same time, he will continue his studies in second semester. It's not that he will be sitting in the first semester placement. That is the procedure. And that time it was the Guwahati University. Now it is the Srimanta Sakadeva University. That part is again, the syllabus has changed.
Yes, Mr. Vaidya, tell us. You are appearing for the medical council.
Yes, my lord. Outset, my lord.
See, please come to paragraph 5 of the impugned judgment.
Impugned judgment. Over there,
See,
you
it
observe-
is true to the fact that it is not the petitioner intentionally left before.
Fine.
Initially, he had an accident for which he took left out for 3 years.
Fine.
Then he again suffered mentally some medical illness. He recovered repeatedly. He recovered cannot be after. Section here. Now, since his admission was prior to 2003, can he not be allowed to complete the MBBS?
My lord, in this regard, my lord, during the repetition, my lord, before the honorable single bench also, when the query was only made on the technical aspect, as to
No,
what
the
the
honorable
outer
single
limit, my
judge
lord.
have considered the fact that if the petitioner is allowed to continue with the course, that will block a seat, which is a seat for the subsequent students of the subsequent
Yes, my lord.
or who might have passed lead or something.
Yes, yes, yes.
Now, since it is a case where it is not on the fault of the petitioner,
My lord, may or may not be.
let us assume it is an act of beyond the capacity of
Fine.
he suffered at this way that he could not complete. Why he is not allowed to be, why is not allowed to complete the application?
My lord, with regard to that, my lord, from para 80 onwards, by looking at the document, because what had happened, apart from the aspect of the rule being changed in 2019,
That's
the
true.
Honorable Division Bench was free to ask the National Medical Commission for its opinion as to whether it should be allowed or if there is something else that the Commission would like to add. In this. Now, my lord, the first aspect, because Lordship had put that query first of all, the Commission. My lord, the thing is that today, if there are 100 seats available, the certain medical college or in all the medical colleges in Assam, 100. So, as per my lord, the need there are 100 students, all the quotas, respective quotas, everything. So, my lord, if the petitioner is to be accommodated, or the applicant is to be accommodated, rather. So, my lord, one seat somewhere, one seat to keep going, my lord.
Now
Because,
here
my
what
lord,
happened, that's why the first
it cannot be
query-
made into 101 seats. My lord.
now for that reason we first inquire from this. Because all medical admissions has over 38th of September. That's
Right.
the deadline.
Right.
We are on 5th of August.
Right.
5th of October. Now, when we inquire from Mr. Gogoi applied that because of the last minute some cases of it. So one particular MBPS seat of SCP could not be filled. Could not be filled. So that remained vacant. Today we are on 5th of October.
Right.
The stand of the medical council also that it cannot be 100 plus 1. It has to be only 100.
My lord,
If it
that
is
is one.
100,
That is one of the steps.
if it is 100, 100 on, not
Right.
101. Right.
Right.
So if this particular seat could not be filled up,
Right.
whether in this particular seat, petitioner can take up.
Lordship, then again, my lord, then
Because
the
this seat is not going to be filled up anyway.
That we have, because there are candidates who have passed and who are otherwise eligible, they are in the waiting list. But because of the time constraint, it is not, because it's now online. Otherwise, physically it was possible. Online method it was the last. So we have already did
Now, right, that you have taken some step, if the permission is granted, you will fill up this.
I-
Now, for a MBBS student prior to but that is not the challenge by anyone. There are 5 observations is very
rule or the
and the petitioner here into that MBBS mission in prior to
my lord.
Will he not able to continue?
That aspect is there, my lord. But with regard to this seat fill up, my lord, that my lord, rule, my lord, that the outer limit is not there in the year 2009, my lord. My humble submission, my lord, that cannot be read in isolation, my lord. That cannot be read in isolation. In filling up of seats, my lord, after 1 year, my lord, just like my learned friend said, that because he failed, then he appeared for 1 more year. Suppose the first year he did it twice, then his medical course would probably take 6 years instead of 5 years to be completed. Under those circumstances, my lord, this is permissible, my lord, that there is no outer limit. Or had he taken, my lord, it twice also, my lord, he took 7 years or 7.5 years to complete also for that matter, my lord, because of
But
ailment,
Mr.
because of
Rudra, what we are
some
saying
other
here is,
aspects.
that a case is not a very common,
My lord, my lord.
right? This is absolutely beyond his capacity, because initially he had an accident and medical ailment.
My lord.
It's not that because of his intentionally away from the court.
My lord, that aspect to a certain extent, my lord, if your lordship takes up the affidavit filed by the National Medical Commission, my lord, it's a voluminous one, because judgments have been annexed, my lord. Those we not going to. But my lord, the documents also who he has annexed, my lord, that will be page 81 and 82, my lord. The commission had given observations in paragraph 7 and 8, my lord, with regard to the, I would say, merits which have been forwarded by the
Which
appellant.
para? Which para?
My lord, paragraph 7 and 8, my lord.
7 and 8.
7 and 8, my lord.
Your
Because his
internal.
MRI report at page 18, which your lordship looks at the continuation of paragraph 7, my lord.
Hmm.
Then it is further submitted that after the perusal of MRI report dated 25/5/2010, annexed by the appellant as Annexure 1 series in the affidavit dated 10/8/2023, it is clear that the observation for the surveillance spinal cord was found to be normal. Thus, in a valiant bid to justly fabricated story of the real incident, the appellant is trying to put an emotional angle to this honorable court, which is not true. My lord, those aspects I will not go into, but the commission has looked into the reports, my lord. These are technical things, my lord. Possibly, my lord, we are not experts, but my lord, the spinal cord, the things which actually need to be looked into, the commission on, my lord, direction of this honorable court has looked into and has addressed the issues, my lord, that the appellant has put forth in his appeal, my lord. In paragraph 7 and 8, my lord, those have been addressed, and my lord, the commission has come to a conclusion, my lord, that possibly they would not amount to grounds sufficient for him to be missing the MBBS course for a period of 13 years,
Is not correct.
my lord.
You want to say that-
The documents, my lord, they do not, my lord, justify his absence from his course for 13 years, my lord. So that is the opinion of the commission, my lord. Legal persons have looked into it, my lord. Medical documents also are, my lord, specifically just from this period to this period, my lord. That my learned friend has already addressed, my lord.
So, according to the commission, in this paragraph 7, Now, Mr. Vedu, please come to page number, paragraph 8.
Yes, my lord.
Kindly read 8 and 9.
Yes, my lord, this will be the subsequent ailments, my lord, which is placed, my lord. But that is it, my lord. There is no continuation, my lord. That from this period to this period, my lord. On a specific date, he has got a certificate of ailment, my lord, which my understand has already addressed, my lord. That yes, on this date he is suffering from this. But from this period to this period, my lord, he is unable to attend, my lord. That to the extent that NMC has looked into, my lord, have not found it justifiable that his absence should be this prolonged for the ailment which he has claimed. My lord, that has been further, my lord, reiterated, my lord, in paragraph 80, 81, and 82 also, my lord.
Paragraph.
My lord, 80, 81, and 82, my lord.
Kindly read.
My lord, start from paragraph 79, my lord.
Okay.
79. It is reiterated that the MBBS course comprises of 4.5 years of teaching and training, and thereafter 1 year of rotating internship in various departments of the hospital. Thus, MBBS course is 5.5 years course, and only upon subsequent completing of all the phases, along with lectures, clinicals, examinations, practicals, that a candidate can be issued an MBBS degree by the affiliated university. The applicant has taken almost 30 years to pass his first year professional examination. It is an admitted position that the applicant has discontinued his teaching and training immediately after his admission, and they cannot, after passage of 13 years, claim any right in this regard in view of the statutory regulations of the answering respondent as well as the authority pronouncement of the Honorable High Court. There have been instances, my lord, when the Madhya Pradesh High Court and the other High Court have held, my lord, where a student was, for reasons, my lord, not attributable to him, was also absent for 5 years and then claimed that, he would be allowed to continue. There are instances, my lord, because on those occasions it was required that for such prolonged leave, they require to inform the concerned university beforehand. That for this reason, I have been advised ailment. I might take 1 year, 2 years, 3 years also to be fit enough to join again. So kindly continue this as my absence period. That was the rule of the specific university. Here, my lord, with
There
regard
is
to
no
present
such specific
university,
Doesn't have any
that,
such rule.
that dialogue cannot be, my lord. But my lord, without informing that I will be absent for this, that might amount to, my lord, unauthorized absence and leave, my lord. That is not permissible. That principle would apply, my lord. That rule whichever is specifically present with regard to the present university, that will be applicable. That judgment will not blanketly cover and go against the appellant. But my lord, in principle, my lord, unauthorized leave, my lord, cannot be condoned, my lord, when it is for such prolonged period. And such document, my lord, the commission has failed to find.
Read 80, 81, let us.
80, my lord, it is respectfully reiterated that the appellant is not entitled to any discretionary relief under 226 of the Constitution, since he has been unable to provide sufficient and adequate explanation for the delay, laches, and acquiescence attributable to him, since even after passing of almost 13 years from his date of admission, he has failed to fail the first year of MBBS examination and today is seeking to rejoin the MBBS course. 81, my lord, is possibly on the same line, my lord, same line, repetition of the paragraph. 82, my lord, is significant, my lord. I'll read it, my lord. It is respectfully reiterated that no admission to any NHS college can be made beyond sanctioned annual intake capacity in any year of the MBBS course, and that the Honorable Supreme Court, while rendering its judgment in the case of Mridul Dhar, has made it abundantly clear that Honorable Court should not be justified and would not have jurisdiction to issue direction for any admission in any medical course which is beyond the annual sanction intake capacity. Now, my lord, that one seat which is very, my lord, our hands are also tied, my lord, because any other course, my lord, possibly at times there are instances where 1 or 2 seats in exceptional circumstances can be accommodated. But medical, my lord, the rules are clear, my lord, we cannot increase the seats also, my lord. If it is 100, then it will be 100. But unless it says that at one seat is of some specific quota, so what law will take its course in that regard, my lord, with regard to that. Otherwise, my lord, it's not our prerogative to say that, my lord, we will be accommodating that seat, my lord. Our prerogative is that the 100 cannot become 101. Going to the expedition document, my lord, the commission, my lord, has not found that 13-year period.
That is your stand.
That is my.
So if today, in the absence of any such clear vacancy of any seat, or as Mr. Kure has said that no, if it is given, it is considered an approved, that seat will also be filled.
Right.
Now, is it possible if that seat is not filled up? Let us assume that seat is not filled up after 15 days.
That is a very pertinent query, my lord, but peculiar to me, my lord. If I will spend some time, my lord, to clarify with the authorities, my lord. So it's a very technical question. If the commission had addressed such issue before, my lord, without proper instruction,
One thing you have said, is clear that during that particular period, because there was nothing, because it was a long period, so that the petitioner suffered during the address. But that's something. But we consider other way. Still, there is a dearth of doctors.
Right.
So we think in that way, and if any city is not free, whether it can be.
My lord, if it is not, my lord, then possibly, my lord, you will be more well equipped, my lord, to answer this question whether that one seat can go.
No, as on date, because
my
it is
lord,
clear that one seat could not be filled up because of the litigation.
Yes.
And the state that last moment judgment came or order came, so it was by that time.
Right.
And so it's not.
Right.
But for that purpose,
Right.
as again reiterated, has written to the authorities to consider. If it is considered well enough, now let us assume for the timing, the authorities say no, 30th September is 30th September cannot. In that case, that particular seat
My
of
lord,
MPPS,
that said that ethics code embargo would be applying on the applicant also, my lord, that after 38th of.
he took admission earlier of it, cannot not be a continuous admission. Why he is required to take a fresh admission?
My lord, for the reason, my lord, first of all, my lord, it's a hypothetical situation. First of all, my lord, may I say that when the time of the situation arises that once it remains vacant. In the meantime, my lord, prior to that instruction also coming, I will obtain my instruction as to that if this happens, what we would do so that we do not waste any time subsequently. I will also take my instruction.
Keeping in mind that the petitioner earlier took admission,
Earlier to get it, my lord.
but as of now, we do not know. That may be a situation where the authorities may allow the Guwahati Medical College to fill up. In that case, it's something different.
Right.
Only when if that remains vacant.
Only
then only.
that situation comes, my lord. Then, my lord, under such circumstances, what can be done, my lord, specifically in light to the situation of the appellant, my lord, before you will obtain, I will obtain the instruction. Prior to this thing gets sorted, my lord.
When can you give us that?
I don't think
We will have it.
Basically, airman protest.
That's right.
There is a constitution in the
Subject to the condition.
Sometime is extended, then the wait instead of not like
If at all time is extended.
otherwise, my lord, the middle term is very clear. Okay. Okay, fine. Thereafter, doctrine is mention over notification. Notification dated 25 by Medical Council of India. Their time schedule not to be find in the 75. Their lordship will see the down below the particular chart. Last date up to which students can be admitted against vacancies arising due to any reason. 30th of September. The schedule says by the time schedule for completion of admission process for purchase application. Now, lordship will see by para 14. The academic session commences between 1st of August and 31st of August. The last date for joining MBBS CTS course, 30th of August. However, students can be admitted against vacancies arising to any reason by 30th of September. The date 30th September is not for normal admission, but to be given opportunity to grant admission against pre-vacancy. The adherence to the time schedule by everyone is paramount for the timely grant of admission, commencement of academic session, and for closure of admission after 30th of September. Then, my lord, finally the Honorable Court has my lord, para 32. Having regard to the professional courses, it deserves to be emphasized that all concerned, including government, state, and central, both MCI, DCI colleges, new or old students, boards, universities, examining authorities, etc., are required to strictly adhere to the time schedule wherever provided for. There should not be mixed admission. Admission should not be in excess of the sanctioned intake capacity. Again, cannot be, and in excess of the quota of anyone, whether state or management. The carrying forward of any unfulfilled seat of one academic year to the next academic year is also not part. Now in para 35, the final some observations have been made, directions have been given. Now you will see 30 sub para 50. The time schedule provided in the regulation shall be strictly adhered to by all concerned, failing which the defaulting party would be liable to be participated. So, as far as the Director of Medical Education is concerned, his hands are, he cannot go beyond this, otherwise he will be personally. Otherwise, but though we have got the sympathy for the petition, but sympathy in this particular court, because there are aspiring candidates who, after completing their high school for class 12 standard, they prepare and participate in it, and then after the exam results are given on the basis of the merit in it, the seats alone.
But here the petitioner is not at his fault.
Even then, not for our fault too, or
That's true.
for that aspiring candidate, who otherwise will be declined, not for his fault also,
If there is now,
and this particular document of that,
just Mr. Gogoi tell us one. Since he took admission prior to 2015, why cannot he allowed to continue? Because he is not going to eat up anybody's seat.
That's why I'm saying that bed is not there, Where he will be admitted, He cannot show a copy of the admission of the slip of admission of 2009 and 2023. Will say that this is my admission slip because given in 2009. Now allow me to. Not that, he has discontinued it. Whatever be the reason, unauthorized even. There is no such permission or leave given to him. That whenever you are fit, come and join. And 13, 14 years is too much, Just showing an instance of of that particular person who went to jail and thereafter he completed. Or you will see that the university accepted it. Or you will see that, and this is a news report. We don't know what was the situation there. Times of India news report is cannot be evidence matter report is not report. If the reporting matter, the reporter whatever he felt like he wrote it. Not placing reliance upon that matter. If any citation or judgment of apex court or any other court that can be placed, then the things will be different.
So according to you, as long as that has continued,
Otherwise, yes, there may be in a final year also, a student fail. Immediately 1 or 2 months, exams are held. That is the procedure in MBBS. I can file an affidavit if required. I know that. And that apart, at that time it was a Guwahati University. So now it is Sangha University of Health.
yes, who is appearing for the university? You are appearing,
For Srimanta Sangha University,
you are appearing. What is the stand of the university?
University as of now they have not
The
submitted.
party.
No, it's other.
Okay, in that case, Mr. Whether let us know by next week. Find out possible whether it is what is the view of it.
One case that we like to kind of take but I'll take the
Because no, definitely he will also apply. Thing is this, yes, at the same time, we cannot deprive another candidate from taking admission, like allowing the petitioner to resume his course again. That is clear fact. But what we are thinking, if there is any it remains vacant because of the deadline, and whether in that case the petitioner that and because here is a case, so the classes started from 1st of September. There is a candidate who has already was undergoing first year course for some time initially it wasn't. So for him, he may not allow classes. Find out. We'll see.
Like, I would not have advised the petitioner to come before the court. I came because of there was no time period before 2019. What is the meaning of it? After 2019, time period of 10 years. You can pass MBBS within a period of 10 years. But before that, there was no point. So that is what is, otherwise, well, if it eats into somebody's seat, well, I know I have no case. I am within that period. What is the meaning of that? If it eats into somebody's seat, I don't want to argue on that. I have bad case. But because of the period of time limit, prior to 2019, there was no time limit for passing MBBS course. I think they have corrected in the year 2019. So that gives
That's
me
what
some
Mr.
hope.
Das is saying also enlighten us because there was whoever took admission prior to what Mr. Gogoi is saying is that as long as that particular path continues, so it can be
My submission is that had he been pursuing the course, yes, could not say qualify or pass out in a particular semester, then of course he can continue. But here is a case he has left us, sir. He has not attended the college.
MBBS,
In that case, how can he now be allowed to teach in that particular
but
class?
people passes MBBS course in 10 years. I know instances, for various reasons they
But he
cannot
is
continue.
continuing, not that after
No,
10
no,
years,
no.
let him do,
Because
one
of
instance
sickness
that,
and all.
in such a situation, such admissions are given in the state also.
Therefore, I mean, they have brought this 10 years. Now you'll have to pass it within a period of 10.
so whether any such candidate time limit, there has to be some reasonable time.
Yes.
limit. As there are no such fixed time limit. And his case can just
Yes, that is what it is. Yes.
will pass.
If they say something, then I have no case. Supposing if they say contrary to what your lordship is thinking or I am thinking, then I will have no case. But because that time gap.
Not a clear counsel. heard with the big Gogoi and the council. And the council from the sites. Okay, yeah. One, six. And the council is for just in the impugned judgment, the single judge observed that under the Graduate Medical Education Regulations 1997 as amended, a learner, who has joined the MBBS course prior to the year 2019-20 academic session. There is no bar in completing the MBBS course. However, for a student who had enrolled after 2019-2020 academic session, yes, there is a cap for 10 years for completing the MBBS course. The petitioner hearing, sorry, the appellant / the petitioner hearing took admission for his MBBS course in the year 2009. But while undergoing the MBBS first year course, he met with an accident and sustained injuries and had to leave the course for about 3 years. Though he claimed that he was allowed to rejoin his course in the year 2012, during that period, because of extensive injury, but after his rejoining the 12, the petitioner allegedly suffered from psychomatic disorder from the year 2012 to 2017, during which he could not pursue his MBBS. Later, when he regained it, he approached the Guwahati Medical College of Medicine to allow him return his course. MPP. Spare the petition became petition. The court was two. It was rejected on 2006. On the ground that in the year 2023, S24, the petitioner cannot be allowed to be allowed as permitted to be admitted to the first year MBBS or the next certificate semester as the said process will pick up a seat of a candidate for MBBS will select after going in any only during the deliberation of the matter on being inquired, Mr. P. Gogoi apprised the court that within the cutoff date of 30/09/2023, a seat of MBPS hostage reserved for ST within bracket P could not be filled up as the matter was pending before the court. The order came in the last moment. Very the admission time. Mr. Gogoi further apprised the court that the Director of Medical Education Assam has communicated to the commission, Mr. Gogoi, or to whom? Minister of Health for extension of time to fill up that extension of time to fill up the seat of the forest. Which is left. On the next date fixed, the respondent National Medical Commission there is a time limit for the MBBS course to a student pursuing MBBS who took such admission prior to 2000, 2009, who took admission in the year 2000. But if the seat of MBBS course has been picked up, remains vacant during the so the position of it can be considered that vacancy. Otherwise, when you will have it next week, any day. No, give us a date. The calendars are there on right. We'll have it on 12. Copy of order. We'll see.
He's trying his luck, my lord.
There are certain exceptional cases that sometimes, let's see.
It is a contested case, my lord.
Hmm.
The petition has been declared for mainly on 3 grounds. One, my lord, the tribunal exhibit A, B, and D. Tribunal believed that those are doubtable documents because those certificates were issued not. There is no seal of the office. This is the one reason. And second, my lord, there is some discrimination of name of his father. And thirdly,
Record was not called for.
not called for. This is why, my lord, the record come. In the meantime, he will be matter may be examined, my lord. Otherwise, he is a citizen of India. His father is a citizen of India. His name appeared in the voter list of along with his father in the year of 1985. But only fact is there is a shifting just near his village. After separation, he got separated in the year of 90 and he shifted in near his village. And there, their father's name. So notice may be issued, my lord. And
But Mr. J. Ahmed Learned Council appearing for MS Al-Nabi Learned CPC Standing Council. State Coordinator Hierarchy Assam for Mr. G. Sharma, Standing Council for response number 2, 5, 7, and 8. Mr. A.I. Ali, Standing Council, CI for the response number 3. And Mr. P. Sharma, Government at Assam for the response. After hearing the parties' report of view, that the relevant record of BFT number 482/2018, which Ilanet Foreigners Tribunal number 2 Kamrup
Rural Boku.
Kamrup Art 31 is necessary. Accept. Release this matter for motion. Let's see. Any interim passed earlier?
No, my lord.
Are you in custody?
No, my lord. I accept it. So I may be protected. I will appear before the SP.
Or not? SP.
Well, I will appear before the SP.
SP border rural.
My lord.
Kamrup.
Will
On or before 19.
my lord. Is a lot. This for leave, my lord. But an applicant number 1, my lord, to join along with applicant number 2 and file to file a writ appeal, my lord. The applicant number 1, my lord, is my form, my lord, against which, my lord, the tender has been, work order has been issued, my lord, but the Lawrence single judge has set aside the work order, my lord, of the applicant number 1 form, my lord. So I'm praying for filing leave, my lord, for the applicant number 1, my lord, to join the applicant number 2 and file this writ appeal, my lord. He was applicant number 1 was not arranged as a party, my lord.
You are not a party in the.
Yes, my lord, my form was not a party in the writ petition, my lord.
But work order was in whose name?
Yes, work order, lordship may kindly see, my lord, work order is issued in the name of the form, my lord.
Is the work order?
Work order, lordship,
My lord, page 31
page 31, my lord.
was issued in the name of the applicant.
His Mrs. Biswajit Vora, my lord. Is the proprietorship form, my lord.
Where is the writ petition?
Writ petition, lordship, my lord. Writ petition begins from, my lord. Page, my lord, 45, my lord. In the cost title, page 47, my lord, the name of it, in the 48, my lord. Applicant number 2 was made the party, my lord. Writ appeal तो है.
Where's the order?
My lordship, order lordship, it begins from my lord page, page 136, my lord. The operative part lordship will find my lord at page 147, my lord.
Hard Mr. T. Alam, direct counsel for the and Mr. H. Kottalan.
So 2 and 3, my lord. Here, my lord, perhaps notice will
CGC, yes,
notice.
that's CGC.
My lord, as CGC, my lord.
What is respondent? 2 and 3 in the notice. The respond number 1 is the repetition file WPC number 6700021. Praying amongst others to set aside work order dated 13/11/2021 issued in response in favor of the response number 3 therein, namely Sri Vishwajyoti Pura with regard to the notice inviting tender issued by the respondents in the Northeast Frontier Railway for the comprehensive garbage disposal from Dibrugarh railway station, or
My lord, is from my lord,
what is WS?
my lord,
DP is Dibrugarh.
Dibrugarh, my lord.
WS.
Dibrugarh, my lord. From mechanical workshop, page 80, my lord, from NF Railway Mechanical Workshop, Dibrugarh to my lord, page 80, my lord. Collection and handling and transportation of waste from NF Railway Mechanical Workshop, Dibrugarh to Dibrugarh Municipality Nominated Dumping Area, my lord.
Page 80, where you are reading?
Page 80, my lord, the scope of work, my lord. A. Capital A, my lord. Page 0 of the appeal memo, my lord.
No, that's where they are.
In the name of the work, my lord, comprehensive in the top, my lord. Just after 2 paragraph, my lord.
comprehensive garbage
Disposal.
disposal from Dibrugarh workshop.
Mechanical work.
Dibrugarh to Dibrugarh medical facilities for a period of 3 years.
Yep.
2021. Where the second act was in 2017. By the impugned order, there's been an order dated 25/08/2023. A single judge allowed the application number 670021, setting aside the work order dated 13/11/2021 issued paper of the respondent number 3.
It should be in favor of respondent number.
Of the application number. This application has been filed by Messrs. Vishwajyoti Bora, a proprietorship firm. Placing the work order dated 13/11/2021 issued by the respondent city Northeast Railway. 13/11 or 3/11?
LOE is 1311, my lord.
Letter of
Work order,
acceptance,
work order.
1311 should be, my lord. It's not 3, my lord.
Placing the work order 13/11/20. In bracket. Next,
Annexure 8, my case.
what was the annexure in the writ petition?
In the writ petition, my lord, it is
Work order annexure A of it 3 hearing. And getting a copy of it.
annexure 3.
Annexure A of it 3.
WPC.
And prove that the work order was issued in favor of
Next, Nick.
Messrs. Vishwajyoti Bora. Not in favor of Vishwajyoti Bora. The response number 3 made in setup. And this application, I said, by the applicant Messrs. Vishwajyoti Bora, seeking leave to prefer appeal against the impugned judgment order 25/08/2023. Passed by number six. Corrected application. This category that the message issued by whose provided for respondent. Not but setup. So notice the next slide. 8 weeks. That's it. Petitioner shall take steps on the respondent of one petition or not within 2 days from listing.
May I pay for a date, my lord, because my lord, my work order has been cancelled and subsequently, my lord, at page 148 in my
You
application.
do it first, then make a petition, they make method of.
Abhilash, my lord.
May I please, your lordship? Your lordship, this matter may kindly be fixed to the engaged counsel went to his pick up his daughter from school.
What's your good name?
S. Das.
Yeah. The matter was hard, but well, considering the matter, considering the case, the court is of the view that the records of very RFP KM wherein the impugn opinion is 25 not by landed member of Federal Capital number 5 here. Yes.
Rather, PKR Chaudhary preparing.
No representation on behalf of the petitioner or no name of the standing part which
Matter pertains to promotion from ACS cadre to IAS, and issue is relating to
will not care
yes.
because it is there. Why should you? Yes, madam.
Please, your lordship, matter may be postponed for the day only, my lord.
What happened?
My lord, my senior is out of his station, my lord.
What's the date?
My lord, after vacation, my lord.
16 meter, 2016 meter.
That's what we will
Next week, lordship.
we just
Bye. Obliged. May I please your lordship? Lordship, in this case, brief, last occasion, one of our junior colleague mentioned that brief was with one youngest counsel, Jan Islam. Today morning, this was handed over to me, lordship. I could not prepare the case, lordship.
Okay, Tuesday next, 10.
Look, this petition is against the judgment and order dated my lord 14 to 2017, passed by the Learned Central Administrative Tribunal. My lord, judgment is there at page 80, my lord.
The other side, because brother will not be available from there. On the other side. So against this, the side is not the.
Yes. Yes. On Tuesday next, my lord, if possible.
What is the reason for challenge?
My lord, the reason for challenge is that, my lord, after 10, 12 years back, my lord, the ACR was communicated to me. That is,
But you got an opportunity to file representation.
yes, at that time, my lord, I have given the representation also against the said ACR, and that was dismissed by the Learned
When
Central.
did you have communicated to?
My lord, if lordship may. If lordship may kindly come to page 38, my lord. Against my representation, they have communicated the same.
But you have been communicated.
communicated later on. It is very much clear from the judgment, if Lordship may kindly listen to my lord. Everything is there, Lordship. My lord,
Initially, it was set aside, right?
yes,
Then you are allowed to submit your representation.
Yes.
You submit the representation, it was rejected.
Yes.
Against that rejection, you have approached the CAT again.
yes, my lord.
Now this time the court has rejected, found that your remark, your SCR will remain same, will not be improved any further.
My lord, if Lordship may kindly look into page 66, my lord. My lord, in compliance of the judgment and order dated 11/6/2003, my lord, 13, my lord, they have communicated the ACR of 2001 to and 2005 to 6. That is after a lapse of, my lord, 12 years and thereafter 7 or 8 years.
Thereafter, there was an order passed by the tribunal, right?
Yes,
Pursuant to the order, because whatever the communications that were not made to you earlier.
earlier. Later on, after given the judgment, later on they have communicated. In the year 2013.
And the other.
Your lordship. My lord, impugn order may be seen page 47. But before that, my lord, I want to draw your lordship attention. This petitioner Motilal Shah has died. So thereafter, his legal heirs have been made parties in this case. So our High Court has some decisions that for declaring a person as a foreigner, his sons and daughters does not become foreigner automatically. They should be given a chance. Here is a case where the Gavura adduced evidence. I have
Where is the opinion?
opinion page 47.
The proceeding was against whom?
Motilal Shah. Now he is dead. His sons and daughters have filed IA. That was allowed the last time.
Mr. Sharma,
Lordship.
the proceeding has expired. Now
Lord.
proceeding was found to be a foreigner.
Lordship.
IA.
Let us. IA has been allowed.
Yes.
You have entered the shoes. Okay.
Then, my lord, now we are a party, so as per decision of our High Court, the matter should be remanded back to the tribunal, giving chance to the sons and daughters of the present petitioner, Motilal Shah, to prove their citizenship independently, because they may have better documents. I say their father could not produce something which we can
See,
produce.
there is no such proceeding pending against here the sons and daughters. As
Yes,
on
no
date.
proceeding is pending.
Then
Yes.
why you have entered into the shoes?
Because that was the view of the honorable court that you should be party, and then we filed the case.
But there is
Actually,
petition
that was not necessary.
only against whom there is a proceeding can only
Yes, yes. Then
can
only, yes,
otherwise to
yes,
know.
yes.
Then
In that view, my lord, then the matter may be closed, and if the authority wants to pursue against the legal representatives of the petitioner, then police may file a fresh FRS.
will pass the order other way. So the procedure has expired.
Yes.
As on date.
No, our
There
High
is
Court
no
decision.
such proceeding initiated against the petitioners who have entered the suit of the father. We'll close it. Nothing.
Yes. That is the best.
Even anything is initiated against the petitioner.
Yes. Yes. That is the law actually. That I also mentioned, but the Honorable Court desired that you should file a petition, then only matter would be. However, yes, Lordship has taken the right view and we also want this.
Or Mr. M. Mahmood, learned counsel appearing for the petition. Our petitioners or petitioner?
Petitioner. Petitioner original, now
We
the
have entered
applicants, they are 4 in numbers. No, they are
petitioner. Or Mr.
only one petitioner was there proceeding.
Mr. MSLDP, for one. And the big one, that court is the forest. These are my city council. Just number 3, 6 and 7. As well as P. Sharma, Government of Assam. For the rest of 5. By the impugn opinion dated slash order slash opinion dated 14/06/2018. Please take your seats with me. The learned member of Foreigners Tribunal 9, Nagaon, Assam. In FP case number 485/2016. Fine. Motilal Sutradhar, son of late Radhasaran Sutradhar, resident of village Niz Kotiatoli under Kampur Police Station of District Nagaon as an illegal migrant, the stream of 25/03/1971. On being referred by the Superintendent of Police Order Nagaon. Said Motilal Sutradhar being aggrieved the prosecuting counsel filed this writ petition against the impugn opinion, filed this writ petition on 07/08/2018 against the impugn opinion. During pendency of this writ petition, said Motilal
Died on 20/2/08/21.
one Motilal Saha, son of Tata. Right. Excellent. During pendency of the square. On 20/08/20. On his death, his legal heir Ranjit Saha, Ratan Saha, Sandeep Saha, Prosenjit Saha, sons of Motilal Saha, Srimati Devirani Das, and Anita Mondal, Srimati Devirani Das, Srimati Anita Mondal, and Srimati Moni Saha Das, daughters of Said Motilal Saha, filed an interrogatory application being IA within vacancy number 2004 of 2023. Praying for substitution of their name as petitioner numbers 1B to 1G in place of Said Motilal Saha. And the court, by order dated 31/07/2023, allowed such implement past in fact according to the application. It is submitted by Mr. Mahmood that as on date, there is no such reference against them spending before any of the tribunal relating to their success or as for it. The as there is authentic since there is no such against on it. But so, yeah. Right. Yeah.
My lord, one thing, Motilal Sutradhar alias Motilal Saha.
That is not a case in the
But I have clarified in my WS. Kindly see page 38.
Read petition is everything.
Yes, I have.
That is why you have said son of delays everything. We have.
Rather transcribed.
May it please your lordship, my lord, item 1.3 of today's list, my lord, can it be taken up after the vacation? Some difficulties. Item 13.
But in 14, there is an. No, item 14. 14.
Yes, you have to make some mention.
Matter of art, that is
16, 17, and 18,
17
Lordship.
and 18. Matter is admitted and it was listed for final disposal. Lordship may very kindly give it after 2-3 weeks.
On 7th, Lordship. Another matter has been fixed. No, on 7th.
No, okay. Only.
Yes, 7th.
Oh, sorry.
I'm from
Seventh.
I know.
outer bench,
I know. I'm maybe at Kohima bench.
Lordship.
You are probably aware, brother is stationed at Kohima. You are aware that brother is.
Yes, Lordship. I have seen the routine.
You want 7th of November?
November. As a fixed item, my lord.
Okay. Okay. Just a minute, we'll see how many minutes. Okay, we'll have it on 7th.
Lordship.
Record it. Okay, we'll record your presence.
Lordship. Obliged, Lordship.
May please your lordship. My lord, in this case, there was an order dated 22/8/2023. And this order, my lord, the respondent authorities to take decision about the petitioner, whether he can be declared a citizen or not, being a foundling son. He was the foundling son. Fathers cannot be, he cannot say about his past. He was found in an abandoned child in a railway station and picked up by some person, and they was brought up by others, and they are also no more. The persons who brought up him, they are also no more. And here the paragraph 3 onwards is relevant in order dated 22nd August 2023. Lastly, in para 7, it was observed that any decision may be taken by the government about the para 5 and 6. RKD 9. Online online
একটা collected certificate.
Today, we have not seen Mr. R.K. Dev Chaudhary.
Yes, my
But
lord.
in most of the cases, we have adjourned. There are many, in fact, there the R.K. Dev Chaudhary was the appellant. There is an order passed by the
Yes, my
tribunal.
lord.
What to
But
do?
he is not, he is seen in the court, but not available.
And that report has to be submitted.
Yes,
by
my
him.
lord. Yes, my lord. He is to correct instruction.
Party petitioner doesn't know he's already married 7 children. Great achievement.
My lord, he was found in while he was very small child, my lord. The abandoned child he was found in a railway station, and he was taken up by
Lordship-
some person.
Lordship will kindly see page 58, Lordship.
Critically देखेगी कोर्ट एट ऑलरेडी ऑर्डर
What do you want to show, Mr. Sharma?
Page 58, Lordship, earlier in read petition, Lordship. Everything has been discussed, Lordship. Second para, Lordship, petition.
But the court found that the persons who picked up the petitioner
Yes,
no longer, they have already expired.
Honorable Court found so many contradictions, Lordship, regarding statements of the petitioner. এই যে abandonment or কিছু তারা না করছে না হ্যাঁ হুম হুম হুম
Yes, Mr. Sharma,
Lordship.
since that order has been passed,
It will be based on the submission of Union of India, Lordship.
let us see. Yes, Ms. Devi, what happened? You have received
Yeah,
the order.
Lordship, Mr. R.K.D. Chaudhary was supposed to this one, but he is on legs in court number 17. So if Lordship will fix the matter tomorrow, Lordship.
Monday.
After vacation,
Monday.
Monday. Lordship, Monday is not available.
Tuesday.
Wednesday.
Okay, pair of Amazon. Left. And I will start with FPS.
School record. কিবা আছে কিবা anomaly আছে তোমালোকে anomaly পায়ে My lord, here in this case, my lord, domicile report on the domicile certificate issued by the additional district magistrate in Nagaon, that has been called for, my lord. And also the school's admission register. My lord, we are relying on the domicile certificate. Person serving in Indian Army, and my lord, when he came after serving some period, and he has made D good. Then the proceeding.
Mr. Sitar, what has happened, you know? One matter. Regard to the report. The person concern was contribute reporter is tribunal point that the foreigner division that uphold the Supreme Court certain observation and so be heard by the tribunal again found to be a foreigner of 71 came before. At the time I was sitting with mommy taking care of. We found that the first order of the tribunal, the last order upholding the initial correct on the but somehow for the honorable effect, the record was not the materials whatever in the anyway the order was passed by the respect court. This time again on the there he claimed that he is the brother of particular family, he belongs to a particular family whose brother was putting a high post in Indian defense. He claimed lineage and Mr. MZ Ahmed,
Was appearing.
the senior counsel. Then restrictions are imposed by the Honorable Apex Court, but was returned back. Then finally, Honorable Justice Goswami pointed out, found that the entire claim of the petitioner that belongs to that family or the defense person is found to be bogus. It was pointed out before, Mr. Ahmed Ahmed quickly realized, because second direction of the apex court was to be disposed of by the High Court, not by the tribunal. But twice the tribunal has objected. Mr. Ahmed Ahmed had no other alternative to again pray, because the exercise of the power was placed before the court, being delayed, better be again sent back to the press court. Pause that, clarifying that no further
Accepted.
materials whatever is required. That basis decided, again came back to us. They uphold the order of the tribe. Hereafter, we don't know what happened here.
Hard time.
So it happens sometimes.
Yes, sir. But here in this, here in this case, my lord, I have gone through the opinion. The opinion goes to show that the tribunal has believed the inquiry reports. And inquiry reports, my lord.
We are not on that. Now, what are the linked documents?
My lord.
The prosecutor to?
My lord, Lordship may kindly have the voter list of 1966, page 14. Vernacular, translated copy at page 13. Romizuddin is the father. Haitan Nasa is mother. Lohijan is stepmother. Village Forest Salvada. Then, my lord, 70 brutalist also appearing same thing. Then, my lord, he has relied some certificates, birth certificate, school certificate at page 19, that in reference to the school certificate, their report has been called for, and domicile certificate at page 20, my lord. These two certificates, my lord, is, my lord, now as per the previous order, the report is to be seen, my lord. And the claim of the petitioner is that his defense service, he has a certificate, annexer at page 23, my lord. Page 20, annexer F. My lord, tribunal said that there is this seal of the officer is not proper, but I find in the left side, the seal is proper.
Which one?
My lord, at page 23, annexer F, the service certificate. Here in this case, my lord, he himself is serving under the defense, my lord. He is still serving. Still serving.
Sini. Hah? Report school certificate or provisional certificate? Hmm?
Please take your seat, Mr. Sikar.
My lord.
Yes, Mr. Sharma. Please come this side. Mr. Payang, one Mr. T.R. Gogoi, what is Deputy Commissioner APR? Any idea who is he?
Here, Gogoi, Junior Government Advocate. Junior Government Advocate. Junior Government.
By order it is 01/08/2023. The court directed the respondents in the education department to place the original register, admission register of Kotiatoli High School, Nandapur, Sariali, Ujai, Nagaon, Assam, for the year 24-25. No, no, 48. 1981. That's two. In original. Part the court by the said order is 01/08/2023 also directed the additional district magistrate Nagaon to produce the records based on which did an additional deputy commissioner Nagaon issued the domicile certificate number NMM.33/97/264/25/08/2000 in favor of the petitioner. I, Muhammad Riazuddin, son of Muhammad Ramizuddin, village Albagan, post office, Nandapur police station, Khudai. police station for the Indian district of Nagaon. However, neither the 11 school records.
Lordship, school records are
You have the school record.
Lordship.
Give it to.
itu mau kue.
না মাসালা না
না আমি ক্ষেত্রে স্কুল রেকর্ড আনি itu আনিব পাৰা নাই এইটো বেলেগে লৈ
Lordship, serial number 32. Serial number 32 in the year 1996.
Yes. Genuine production, genuine one. ম্যাজিস্ট্রেটের কথা কইছে
এদিকে আছে কপি আছে কপি আছে
পিটিশন এক্সট্রা কপি
These are not produced before the tribunal.
Lord, tribunal school headmaster was not examined. Not examined.
These are not the exhibits.
প্রডিউস করে দিব
Yes, my lord, school certificate was not
No,
produced.
the transfer certificate, nothing.
School certificate not
Petitioner did not state in his written statement regarding that he was a student of
Yes.
Port Italy High School.
But not proof.
Not even, uh,
Evidence of the public. Page 57. Page 57 and 51.
School documents will be an
School documents to be review petition. My lord, he has filed a review petition, and review petition he has made mention about the school certificates, service certificate also. So the school certificate. School certificate G.
you filed review petition before whom?
Before the tribunal,
Not here.
not here.
The record doesn't show anything.
Review की order. Review की order. Tennis कराना है अपनी review. खुद से. Tennis की. আমার পেজের নাই review has been filed, my lord. Tribunal said that he has no power to review. Annexer at page 60 onwards, my lord. Lord, he may remand the matter to take note of this school certificate and allow him to edit evidence. Tribunal, how the tribunal can say that he has no power to review? He has the review, my lord, power. And the domicile certificate, that is a, my lord, public documents. Well, apart of the school certificate, we have some other documents. The provisional certificate, service certificate, these are public documents. Well, the service certificates over the service certificates and domicile certificate is not required to be proved.
Mr. Hang, both are not the documents before the, they are not exhibit. Now, one more issue. Notice was issued to one Riazuddin, son of Ramizuddin of Milik Post. On 3 occasions, notice was issued. Now, all the time, the notice returned unserved because the person concerned could not be found in the area. So, first it was issued on 4th of April 2018. Then 25th of June 2018, same reply could not be traced. Needs further time for verification. Then it was issued on 22nd of October 2018. Same thing could not be found in a particular village. But the petitioner filed a Okalatnam on 1/12/2008, saying he is a resident of Milikot. If you have the written statement with you, there is a part. Yes, it starts as page 30.
Yes.
Resident of village Milikosti. School certificate Salbagan. In the school register on Riazuddin, OBC, on Muhammad of Ramizuddin, Salbagan. But in the certificate, transfer certificate, Riazuddin, son of Muhammad Ramizuddin, inhabitant of village Salbagan, Tangia.
Salbagan and near. Salbagan is a big revenue village. It has several parts. My lord,
You know,
Milik Bosti,
we have been to that area, you know.
my lord.
So, you know,
That has been recorded in the opinion also.
so it is person could not be found in the Milik Bosti. Police verification is of Milik Bosti. That's how the forwarding by the SP border was. The person contact is from Milik Bosti. The person before you is from Salbagan. School certificate, Salbagan. Was not placed, not exhibited. Domicile certificate, Salbagan. Milik Bosti and Salbagan is not the same area.
My lord, Milik Bosti, my lord, Salbagan is the, my lord, revenue village. It has several parts. Milik Bosti, my lord, my lord, Malipuri. My lord, in part, in their part, The Milik Basti, they belongs to my lord Manipuri community. My lord. The Manipuri community, Manipuri Muslim, my lord. He is not of my lord, other Bengali speaking or Assamese speaking Muslim.
In his WSN, my lord, evidence he has stated he is from Milik.
Milik Basti.
But certificates, documents are of Salbagan.
Anyway, let the report come. But what we have found from the record is this. Mr. Sharma, now the education department has produced it.
Yeah.
Pull it up. The Ms. B. Dekal, Understanding Council, Education Department. Here's the admission register of Patiatoli High School, Nandapur Sariali. That is from 17/1/1991 to 31/12/1995. Wherein the admission register of students of Patiatoli Chatan, name of one Muhammad Riazuddin, son of Muhammad Ramizuddin of Salbagan. At serial number 32. On 08/02/1990. Basket. On being transferred from Kotiatoli, MS. Pardon. Folio. That's On the next date fixed, the Deputy Commissioner Nagaon / Uday as the case may be. Shall produce the records, relevant records, on the basis of which domicile certificate the petitioner of village Salvagat Pragya was issued to him. Terms of the order. Please stop. Filling with. Please stop. 9th of November. Mr. Sharma, already order has been.
Extra copy.
Showing reminder.
Huh?
Fixed on 9th of November.
Extra copy maybe, sir, I will send, fresh letter I will send, ma'am.
The name of the school is Kothaltoli High School. Kothaltoli High School, name of the school.
Not Kothiatoli.
Not Kothaltoli. Kothaltoli High School. Kothaltoli.
Kothaltoli High School. I'm wrong.
Lord.
Kothaltoli.
Kothaltoli, yes. No. My lord. Check number.
Item number is 2.
None appeared for the petitioner.
We have received a case judgment.
Let's stop.
May I please your lordship, my lord?
Just a minute. In the queue. Yeah. Bail granted, appear before the Special Judge NDPS Lakhimpur, North Lakhimpur, on or before 16/10/2023. There are certain conditions.
Your lordship, your lordship, page 25.
We have granted bail
Obliged.
because on last
Your lordship,
occasion have heard Mr. Azhar.
yes, ma'am.
Your name has not been indicated now. If you want that first page, we will change it.
No, man, I'm obliged to your
Mr.
lordship.
Azhar, Mr. Azhar had given certain judgments also.
My lord, yes,
We have
sir.
indicated bail has been granted.
Obliged to your lordship.
But there are certain conditions
No, that's I will fulfill, my lord.
to appear before the Judicial Magistrate First Class 2, Karimganj,
My lord.
on or before 16/10/2025.
1610. Obliged. Obliged. 2 persons, my lord. 2
Two
persons.
person.
Yeah.
The other person, there are nothing in the record as
Yes.
it's against the first petitioner who is the brother of
It is
the
one also got acquitted, my lord. The earlier case was mentioned.
that case